Please welcome Colleen Robinson. She's been a lawyer for 13 years, graduated from law school in 2009, correct, Colleen?
Yes.
Awesome. You started with family law and then got connected to estate planning through your previous firm, and you have loved it ever since, right?
That is right. I have found a whole new way to serve families all over California now, thanks to Zoom. That's an unintended benefit of COVID. It's brought everybody up to speed with technology, and we can all utilize it and connect with other people that we normally wouldn't have been able to. So now, I'm all over the state, so it's great.
Awesome. Awesome. Well, anything else you'd like to share before we jump in? Or are you ready to take it away?
No, I'm ready to go.
Awesome.
I am.
Well, let's
Thank
do
you
it.
so much. All right. So just a little bit further about me. I'm a partner at Landon Rainwater Robinson. I have two other partners. Brad is the guy there in that picture. He does business law and family law. And then my other partner, Rebecca, she does family law and some estate planning as well. So collectively, we can really serve all areas of our clients' lives. And between the three of us, we have over a half a century of legal experience going all over the state of California. So we've been around, we've heard and seen just about everything between the three of us. So what my objective here today, I have a couple for you guys, is that one, I really want to be a resource to you and your clients. Two, I want to give you some information because I know that you're limited in what you can tell your clients, but having the background information on ways to take title and the potential consequences of how you take title allows you to have meaningful conversations with your clients. So I want you to be able to have the vocabulary and the understanding, the basic understanding of the different options a client of yours could have. And then also having that knowledge, you could foresee some problems that could be out on the horizon and how to prepare and strategize for them. Because clients like proactive professionals, not reactive professionals, and they don't like delay. So when you first meet with a client and you're able to pinpoint a potential problem and then come up with a resolution of how you're going to deal with it, clients love that rather than, oh yeah, by the way, we're not going to be able to close or whatever because of this, and this issue, and they don't like that. So reactive versus proactive. And then lastly, I want to be a part of your closing team, and I'm going to talk about that on the back end of my presentation. So I understand right now in this economy that there's a variety of wild elements. We have inflation, we have interest rates have just gone up, we have low supply in the housing market, we have supply chain issues. Like with me personally, it's the formula issue. Like you probably would haven't thought about that, but I have a 10-month-old, so the formula supply chain issue is a big issue here at my house versus like getting construction materials and things like that, or cars that people are trying to purchase and they can't. And then also, as I understand about the real estate market, is that there's a ton of realtors. So the more information that you have, the more you can have better conversations with your clients and strategize with them, the more you stand out in the sea of realtors. And you become more invaluable, which makes you more irreplaceable, which is the place you really want to be, is you want to be irreplaceable. So, and you gain respect and trust from your clients, and they're more than likely to hire you and refer you out to their friends and family as well. So the topic or the title of this webinar, avoiding catastrophe, it's not just sensationalized. I know catastrophe is like such a big word, but it was chosen purposefully because the way you take title can have drastic, catastrophic consequences on the back end for an owner's family, for example. And so I want to talk to you guys about that. And again, it's just having the knowledge base to supply you with so you can have those conversations and planning with your client. But I just would like to know, how many times have your clients asked you, how should I take title in my new home? Like by a raise of hands or between the two of you, have your clients ever asked you that?
All the time.
Yeah. So, and you're limited because you're not a lawyer and you can't give legal advice. So you're kind of like stuck in the rock and a hard place. And I'm sure even with Tyler, like he can't give out legal advice and the escrow officer can't give out legal advice. They're like sliding the vesting sheet for a client to decide. And they might be like, hey, we have a couple options, eeny, meeny, miny, mo, and not knowing what the consequences are. But so again, I understand it's a tough line for you to walk. So why is this so important? Again, I was talking about how it can have catastrophic consequences to a family on the owners. So one is that if depending on how a house is titled, it may have to go through the probate court. And I just want you guys to keep in mind when I use the word court anytime during this presentation, I want you to remember CCD: conflict, cost, and delay. So conflict is that if there's no plan in place, or even with the will and it's ambiguous, you don't know what's going on, chances are, and you're dealing with money, families are fighting. And they're not in the right headspace. They're lost a family member, like they're just been blindsided by having to go through a legal process. It's a recipe for disaster. Cost is, people don't realize the cost of going through probate is approximately 5% of the value of the estate. So if I just took a house, for example, and this was actually, so like a $600,000 house, mom and dad paid it all off and they pass away. The average cost is 5% of the estate value. Now, if they only had the car, the house, which most people don't, they have other accounts, they have cars, they may have more than one property, but 5% of $600,000 is $30,000 that's going to the state of California and going to other professionals that get dragged in or required to be brought into a probate case. That's $30,000 that the family doesn't receive. It's coming out of the estate. And then delay. The average probate case throughout, I'm speaking about Southern California because that's my experience, is 1 to 2 years. And that's not like Michael Jackson's estate. That's not Kardashian money that I'm talking about. That is run-of-the-mill. Bob Smith owns a house, and that's how long it takes because you're on the court's calendar and it's very, very impacted. So it's avoiding probate court, or it's a recipe to get to probate court if you don't know how things are titled. And then there's also the tax consequences that are involved, and how owners decide to take title may either subject them to heavy capital gains on the sale of the house and inheritance consequences and control issues that they didn't even know about because they didn't seek or thought to ask additional questions or talk to an attorney. So this is kind of what should be in the back of your mind as we go through the ways of how to hold title. So there's 3 different categories on how you can take title, or 3 different buckets. So you have sole ownership, co-ownership, that's with 2 or more people. And then the third category is business entities or trust. And we're going to go through all of these. So you guys are now sitting like as if you're in the first year of law school, because this is where we're going back to essentially. And I just want to throw out a disclaimer. I have examples in here from Outlander. I just finished the 5th book, and rather than using Bob and Joe or like Sally and Tom Smith or Mr. and Mrs. Homeowner, I'm using names from Outlander. So it sounds like they're real people, but they're completely fictional. So I just want to say that. And if you don't know what Outlander is, you guys are just going to be like, she's weird. But anyway, I'm going to go through them. So going on to sole ownership. Sole ownership is what exactly it says. It's one person acquiring property. And it could either be a single person as an unmarried, or even a married person could take title as their sole and separate property. There may be reasons why a married person would take title sole ownership versus the other ways to take title with the spouse, but it really depends. So again, using Outlander as an example, like with Jamie and Claire, out foraging for mushrooms and not really getting money for her medical practice, she may not qualify for the income necessary to get the loan on Fraser's Ridge. So the lender may require her to sign off for her to be excluded from the loan so that Jamie could qualify. So there could be something along those lines. It could be property rights too. There's a variety of reasons why a married person would take it as a sole ownership. But also, regardless of how either one of these are taken, this will go to probate. If there's a will or there's no will, this will have to go to probate to be distributed to the next in line in terms of heirs. So that is sole ownership. Going into co-ownership, there's 4 different ways 2 or more people can hold title to property. Those 2 or more people may not qualify for all 4 examples, but just so you understand in this category, all the different possibilities. So there's joint tenancy, tenancy in common, community property, then community property with right of survivorship. And they're all vastly different from one another. And we're going to go through that. So first one's up, which is not common, despite its name being tenants in common, is it's property that's owned by 2 or more people in undivided interest, which can be unequal. And what's interesting about this is that those rights don't have to occur right at the acquisition of the property or possession of the property. You could keep adding owners later on down the line. So this particular example is great with real estate investors. So in areas where the cost of living is really high, down here in Southern California. So you may have clients that perhaps individually, they wouldn't qualify for a loan for that beachfront property that they want to make into an Airbnb, for example, but collectively they're able to buy it, enter into this enterprise together or this relationship with each other, buy the property, and then do whatever it is that they want with it. It's great because even if you have 3 people, let's say Bob, Tom, and Jack, and Bob suddenly has an ex-wife he's got to pay out, he could sell his interest. And now Steve is the new owner in this 3-way property enterprise, I guess. But it's also that brings a negative too, because Tom and Jack may not know Steve, and Steve may not be privy to their plans with this property, or that Bob dies. Now you've got Bob Jr. and Sally who inherit the property. And Bob Jr. has crazy ideas what to do with this property, like another Fire Island, if you guys knew what happened with Fire Island, or whatever the situation may be. So it has some cons as well. But it's also not, like I said, it's not that common, despite it saying tenants in common. There's also the possibility that one of the owners doesn't pay their share of the mortgage or taxes, and then the whole property is subject to foreclosure. So that is a huge negative. And then, however, these people, if one of these owners die, their share, regardless of the will or no will, it has to go through probate. So now the property is being brought into a probate proceeding, and it's just time and money and worry and stress that's getting involved here in this particular situation. If you have any clients that are contemplating or real estate investors, I strongly suggest you refer them to a business attorney, because they should sit down and talk about how this relationship's going to play out in case one partner or one owner decides not or defaults their portion of the mortgage or the property taxes or whatever. So they've got a plan in place, and you're doing damage control on the front end rather than this all unraveling and they're all tied to each other now legally, and it's a big giant mess. So my partner does business law, business agreements. So that is certainly another tool for you to keep in your toolkit, your real estate agent toolkit, your realtor toolkit, to get your client the assistance and legal advice that they need before jumping into any of these situations. The next way to hold title is joint tenancy. So joint tenancy is owned by 2 or more people. They do not have to be married. They have equal interest, like 50-50 interest in a property. And it's or if there's 3 people, 33 1/3, and you can do the math, 4 people, 25%. And it's subject to the right of survivorship. So what does that mean? It means that if there's 2 people, they both own 50%, first owner dies, now that surviving owner owns 100% of the property. So that may seem like a great idea because it avoids probate on one of the owners, but now you still have the other owner that still needs to be probated upon their death. This was a popular choice for married people back in like the 80s. So if you have older clients that purchased property way back in the day, you may see joint tenancy because having community property or community property with right of survivorship wasn't a really popular option. And with how estate planning was going back in the 80s, having a trust and things of that nature wasn't beneficial. So joint tenancy was one of the only options. The con, as I said, is that it subjects the property to probate. But the other cons, which I think are even more significant, is that you lose out if they're a married couple, they're losing out on the double step up in basis. Essentially, if you have a client that signs up for joint tenancy, they just raise their hand, flagged it to the IRS and says, hey, we want to pay capital gains by a lot. This has a significant impact on your clients. And also, which is kind of hidden, and if you think about it, is also when the first owner dies, the surviving owner now has full control of the property. So I'm going to go back to Claire and Jamie, and even if you don't know their story, but they own this huge piece of property. They have one child together, and Jamie has like 2 other kids. And, throughout their lifetime, they talked about how upon their death, all 3 of the kids are going to equally inherit their property. Well, Jamie goes off and fights in the Revolutionary War. I'm such a geek for talking about this, but he goes and fights off in the Revolutionary War. I don't know what actually happens because I haven't read it yet. So don't tell me if you've seen it or read it. And he doesn't come back. That's just in this scenario. So I'm not giving you any spoiler alerts because I don't know the conclusion, but he doesn't come back. There is nothing in place in terms of estate planning. It's just that him and his wife own this in joint tenancy. Well, now Claire has Fraser's Ridge all to herself and she owns all of it. And now she gets to decide what to do with it. So she's only met Jamie's son once, and he's like an earl or something like that and is worth $1 bazillion. So he doesn't need their property. And their adopted son, he's not legally adopted. Fergus is driving her crazy. So she decides, I'm going to leave it to my daughter, or better yet, I've met a new Scottish guy and I'm going to leave it to him because I'm too busy now with my medical practice. She can do that. So she has absolute control. And when you take this example, it's not a far stretch to apply this to a blended family. So you have a husband and a wife. They were married before. They each have their own kids. Husband, they always talked about how the property is going to go to all 4 of their children. Husband passes away. Wife now has full control. She never liked her stepkids in the first place. Now it's going to all her kids, and it's a big mess. So that is with joint tenancy and how that works with joint tenancy. Moving along to the next category is community property. So this is only available for married or domestic partners. They own the property equally, and each spouse can dispose of his or her one half by will, by will or by no will, by intestate. So I said that the con to this is that it's really incomplete estate planning because it's going to have to be probated not once but twice, because the property doesn't automatically go to the surviving spouse. And the courts have to decide what to do with it. So that it'll have to be probated upon the death of the first spouse, and once the second spouse dies, now the whole property is being probated. So that has unintended consequences for the family as well. Like, we have to do this once but twice. Like, that's not fun at all. Now we've got the last one in this category is community property with right of survivorship. So it's very much like joint tenancy, except that now you get the step up in basis because we're in community property. So that's a benefit. You avoid probate after the death of the first spouse. Great. But it has to be probated upon the death of the second spouse. And it still has this underlying control issue. If that could be problematic for the family, is that he who dies last wins, in terms of control, and they can do whatever they want with it. So I was in family law for a while, and I saw some crazy situations and scenarios. Mom could, find a new boyfriend who's like, I'm a great real estate investor, sign over the deed to your house. And she does. And it's just a disaster from there. Now the family's lost their biggest asset, and mom's homeless, or she thought, she gave it to him and they were supposed to do this together, and mom didn't know, and she was hoodwinked essentially. So it could, again, there's problems even with community property with the right of survivorship. I have on the next slide, this is just kind of understanding capital gains and step up in basis. Full disclosure, full disclaimer, star asterisk asterisk footnote 1, I am not an accountant. And I'm going to be honest with you, attorneys are terrible at math. Anytime there is math presented in a case, we hire accountants. So I just, full disclosure of this, I make the numbers as simple as possible, because also when I start talking about numbers out loud, I don't know if this happens to any of you guys, I always screw up the math in my head. So I try to make this as easy as possible, but that you can understand, again, with money, the consequences of titling property incorrectly. So Joe and Mary, they're married. They purchased a house in 1985. This is possible for $100,000, maybe around here. He passes away, and now in this market, it's worth $1 million. So the equity is $950,000, or but between the two of them, or it's $900,000. See, I already screwed up the math. $900,000 is the equity. When Mary wants to sell the house, there's a capital gains of $450,000 on that. So while she's living, I'm sure there's a 1031 exchange that she could use. But when she also dies now, and they own the property and joint tenants, there is a tax liability still of $450,000 that their family thought they were going to get a house of, $1 million or split $900,000. And now they've got to pay a bill to the IRS of $450,000. So that's huge. If it was owned by community property, there would be no capital gains, because it steps up with the assessed value steps up with each death of the spouse. So that is significant. So that's just my not real life example, but just so you can understand with numbers. So now this gets to our last category, and this is business entities and trusts and owning property. So business entities can own property, corporations, partnerships, limited liability corporations, limited liability partnerships can go in and purchase property. I don't have much more to say on that, because it's not my area of expertise, but it is possible, and businesses do that all the time. And then we're talking about trusts. So a revocable living trust, an individual can have a trust, married people can have a trust, unmarried couples can have a trust. So it really encompasses just about everybody. With a trust, there is no court. So there's no fees, no attorney fees, no appraisal costs, not having to put the house on the market if you don't need to. There's no delay. So I mentioned that the average probate case is 1 to 2 years, and that's if everything goes smoothly. And it's not public. So I don't think a lot of people realize how public probate proceedings are. So I'm going to give you a real life example here. I did an estate. I probated an estate, and you have to put an ad in the paper notifying all potential creditors that there is a probate, and here is where you file your creditor's claim. So you put it out there to give notice to everybody. And you guys may find this funny, because this may have been you at one point in your career, because we all have to start somewhere. As soon as that posted, I started getting 5 to 10 calls from real estate agents, because they know more than likely there's a house, and that house has to be sold. So I would imagine that's a pretty easy way to try to find leads, is going through the legal ads in the newspaper. But it's very public, and so anybody can see it, because you can read the ad. It's out it has to be in a common publication, and you can go down the courthouse and you can see what they had, and everything gets filed with the courthouse. Nothing is confidential. With a trust, because nothing is filed with the court, nobody knows about it. It's not up to public. It's not open to the public eye. So when you have like kids, for example, minor children that are looking to inherit it, and They're not having to be subject or being contacted by people. It's really important. And like in my situation, in my family, I have a law enforcement family. Confidentiality is really important because now also it's confidential because of how title is taken at the recording office. It's not in your individual names. You're taking title in the name of your trust, which you could choose any name you want. So it's helpful if confidentiality is important for your clients. That is a huge consideration because you can't go through. It's very easy if you're doing a skip trace or doing title record search to look up individuals and see when they've owned property. So that's a huge thing as well. Trusts are easy to amend and easy to change. So you can amend your trust as many times as you want. You can add assets, take assets out. It's designed to be flexible because we are ever changing people. So the idea of establishing a trust, and it's supposed to grow with you and your family, that you don't need to discard it and start over every time you acquire a new asset. And then if you're married, you still get the benefit of the double step up in basis as well. So that's kind of just a brief intro to a revocable living trust and why you can see how different they are from the other ways to take title. And that also, because the title is in the name of the trust, which most people don't quite understand it, but because of the way the property is taken in the name of the trust, you don't need to go to probate court because probate is taking an asset in the name of someone who's died and transferring the asset. You don't have that dead person the ability to write on a deed to change title to a piece of property. That's what the judge does. But in a trust, because it's owned by the trust like a business, all the assets go into the business. It doesn't matter who is managing the trust or like who's managing the assets. If it's Bob and Bob dies, he's got a successor trustee who's now managing the assets. So it doesn't matter who the manager is, as long as the trust is in place, those assets are going to avoid court. And that gets me to my next point is that trusts, they need to be funded and they need to be properly funded to avoid probate court. And by properly funded, I mean, most attorneys, they'll transfer a piece of property and they won't transfer anything else. They won't give the clients the tools necessary or to be able to do it themselves to transfer the remaining assets. So certainly if you have a trust and you forget to title something into the name of the trust, it's an easier court process to get things transferred into the trust even after the passing of the trustors. But you can avoid that if you have the proper guidance and the proper tools. And that's what I ensure with all my clients is that their trusts are properly funded. Because when they're not properly funded, it's a one-way ticket to the probate court, which is what we're trying to avoid. That's why they pay me, why they hire me. And that goes to the next point is that trust must be updated. So my practice is once every 3 years, that's the maximum amount of time I'll go and touch base with my clients, the longest I should say. But depending on the clients, it may be more regular than that. I have a membership program where we meet every 6 months, every year, just to make sure that their assets are always properly titled into the trust. So if something happens to them, everything is seamless for their family. So I don't know what your protocol is when you're onboarding a new client, but it's always worth the extra step just to make sure you understand how that property is titled so you can foresee any potential issues and any weird things. People do interesting things all the time and they might not know why they're doing them. So as I referenced before, I really want to be a partner for you. I want to be on your team. I want to be a resource for you and your clients because you can't give legal advice. And that's what my license allows me to do. And also if you're taking this and realize, oh my gosh, I have a trust and it's been over 5 years, we haven't done anything with it. I want to be a resource for your family as well. So, and I'd love to meet with you, talk to you where you are with your business. And then I had mentioned too, being a part of your closing team. So I know that real estate agents give out from my experience, fantastic closing gifts. And to really make it personal and meaningful for your client, I would love to be a part of your closing package. It wouldn't look like this, but so you understand that concept. of giving your clients essentially $1,000 coupon for estate planning. So I do, aside from like the initial consult with the client, when I sit down and do family wealth planning sessions, it's a 2-hour meeting where we actually get into the nuts and bolts of designing an estate plan. I generally charge $750. I would waive that for your client, and then they would get $250 off any package that they choose. I have 3 packages. And this would be, I don't know why, but this was on gold paper, like, so it stands out, or however I could fit it into your closing package, thank you gift to your clients that would match with your branding as well. So I have, I think I'm pretty up to date with my Canvas skills, so I can transform just about anything. So the next steps is really look at your own trust if you have one. If you're interested in the golden ticket, or we can name it whatever you want, please contact me. I'd be more than, I can give Tyler has all my contact information, or I can get your contact information too. Schedule a call with me to how we can collaborate. If you're needing to review your own estate planning, give me a call as well. And then if you're interested in being a part of my newsletter, I send out a weekly newsletter, which you might think, like, how could you have that much content about estate planning to send out a newsletter every week? You'd be surprised, because it touches every facet of our life. So I really try to keep information salient to everybody and interesting. So please, I'd love to add you on there. And I'm really proud of this. I made my own QR code, so you can scan it. I scanned it. I tried it myself. It brings up not a super fancy business card. It's not my business card, but it has all my contact information on there. You can just click right on the email. It gets my email address, my phone number. It's a textable phone number. You've got all my comments. Here's our Facebook page. We have 2 different Facebook pages. Our website is currently being designed, but it's coming soon. It's going to have a bunch of information on that as well. So with that, does anybody have any questions about any of the content, or maybe estate planning or something you heard that's weird? I'd love to answer that.
This may be for Tyler, but is it when we transfer real estate, everything's always taken out of the trust, right? With the mortgage and everything, refinancing and all of that, everything's taken, nothing's transferred in trust? Or
what do you mean that nothing's transferred in trust?
Well, so I know with clients, they have a property that's in trust, and then when it's refinanced or it's sold, it's obviously taken out of trust. Like I've had clients like the one that I referred over to you. Right. So nothing is done in trust when the property is transferred in a real estate transaction. At least that's what I've seen. I don't know if there's exceptions to that. But that's something that I always ask my clients at the end is like, do you have a trust? Because the property needs to be put back in it.
Right.
And I know people that purchased and then forgot to put it in trust. And yes.
That's a big problem, because now you're leaving one of the biggest, most expensive, valuable asset outside of the protection of the trust. And I think that just comes with people forget to tell the escrow officer too, like, hey, by the way, I have a trust. And there's a document within within a trust plan that they're supposed to give over to the lender or to the escrow officer that says, hey, I have a trust, and this is its name, and this is the official document, so that you know that it exists. So I think that's just like clients forget about that too.
Well, and I know too that a lot of times we can't record in trust. So it has to be recorded as individuals, and then it can be put in the trust after recordation, but it can't be transferred. That's what I mean. It can't be transferred in trust. I know when there's a mortgage, the mortgage company a lot of times will not let you do that. It has to be individuals. And then they forget that it was taken out of trust or not put in the trust. So it's kind of a double check I do now when I close on deals, because more often, well, every single time it's in an individual name, and people assume that it's just, it miraculously like transfers to the trust without, without actually a deed transfer, which you have to do. So,
right. Yeah. You're out. I have a friend of mine who's going through that. She's in the trust administration. Her aunt just thought, because it was referenced in the trust, that was in the trust, one of their assets, but it's not. You have to go, it's for a pension. You have to go and change the beneficiary to the name of the trust, but she just assumed because it was mentioned that I'm done. So I think you're right, Connie. It's like another touching point with your clients and giving them that valuable piece of information too. Is like, hey, if you have a trust, you got to make sure it also gets transferred back into your trust.
Yeah, they forget.
Yeah. Any
Colleen,
other?
where are you located?
My office is in Temecula.
Okay. Okay.
Yeah, I'm right on the intersection of Inez and Rancho, California. So, like by the movie theater, by Chili's over there in front of the pond is over there. That's where my office is located.
Got it. Got it. I asked that because you mentioned that you worked with clients all over the state through Zoom. So is that another way that a client could potentially set up a meeting with you
Absolutely.
if
That's
they're not available?
Yeah, so I have clients all over the place. So that is really the benefit of what happened with COVID, at least in my industry, is that now I can, because my license is good everywhere, I can coordinate mobile signings, mobile notaries. It can go to my clients. So I can help clients anywhere, virtually anywhere in the state of California. So yeah, that's a great question. And I'm not bound to our geographical area that they have to come to Temecula.
Okay. Perfect.
Yeah.
I have a client that comes to mind, and now that I have Tyler here and you here as well, Colleen, let me explain their situation a little bit.
Okay.
Give me some feedback. So they are a couple who purchased the house under a VA loan, but they don't like each other, and they're going to go ahead and get divorced shortly after. How long do they have to wait until they get divorced with the VA loan?
That
They
is
have to be refinanced, and now her concern is that the estate can be taken from her because of her ex-husband, and she wants to put it in something that secures it.
okay. So this is a family law question.
Okay.
Okay, so I don't know about if there's any tricky situations with the VA loan specifically, and like if there's a waiting period with like filing for divorce. I've never heard of that before. That would be more of a Tyler question. Yeah, a Tyler question. But here's the thing: is that when you file for divorce, you are unable. There's what's called an automatic restraining order, and that's not an automatic temporary restraining order. That's not a restraining order that you hear about on TV or like domestic violence related restraining order. What it does is it legally freezes everything. It's not an actual freeze because people still do things they're not supposed to do. But the idea is that you're not to be selling assets, you're not to be transferring things, liquidating accounts until a final judgment is made. So you can't try to cut somebody out of an asset that's theirs. Does it happen? Yes, it does. But there is consequences to doing that after somebody is served with a petition for divorce. So I have never heard of like you have to wait so many days like before you could file for divorce. There's nothing that he can't take the property away from her. If they're both on title, he can't do that. And there's also this automatic temporary restraining order that would be in place that would prevent him from doing funny things like that, I guess, if that answers your question. Because if he does go and tries to sell it or deed it to somebody else, now he's on the hook to be penalized by the state of California, and those consequences are severe.
Okay, so maybe this will help out. They had an agreement to purchase the property. They're not together. They don't live together.
They're not married? Are they married?
They are married.
Okay.
But they've been separated for years.
Okay. Is she on the deed?
She is on the deed and he's on the deed.
Okay.
Yeah.
Well, so if they file, it's the same thing applies. As soon as you file and serve the other party, there's an automatic temporary restraining order that prevents anybody from doing funny business. And that would go under the category of funny business, is that you're trying to do something to prevent an out spouse from getting what they're entitled to. So he would be under scrutiny if he does anything weird like that. because people think they're smarter, they're smart when they do stuff like this. And what they fail to realize is that family law attorneys and family law judges see this stuff all of the time. So they're quick to the chase, and they are wise when it comes to shady behavior. And they know people do this every single day. They see it every single day. So he may think he's smart, but he's not smarter than what these judges and these attorneys see every single day.
Can she go to you for a solution on planning that estate?
She can call my office. I don't do family law anymore, but my other two partners do.
Okay.
So she can certainly call them to discuss her rights and strategize for her family law case.
Okay, yeah, because she hasn't filed divorce yet. That hasn't taken place, but her biggest concern is the estate.
The house. The estate is like when someone dies. So it's just, you're talking about the property. Yeah, the property. Yeah, what is going to happen with that piece of property that they're not living together and he might do something shady with it.
Yeah.
There's other tools available too to her. She talks to a family law attorney. There's like a Liz Pendens you can file that notifies like, hey, if it was going to go into escrow, you file a Liz Pendens, or you put it out there that, hey, this property is subject to court proceedings. But it's not favorable because you already have the automatic temporary restraining orders in place, and we don't like to cloud title if we don't have to.
Okay. Okay. I'll have her reach out then.
Yeah, please do.
Yes. Thank you, Colleen.
Yeah, of course.
Tyler, did you want to jump in on that?
Yeah. So regarding the loan side of things, are you asking what she would be able to do later on, or what he would be? Is she the veteran or is he the veteran?
He's the veteran.
Mm-hmm.
He does not live on the property. She lives on the property and pays for the property, everything.
Got it.
On
So,
paper, he's on the loan. He's on the
got it. So are you asking more so what she's going to be able to do?
Yeah, to remove him. Essentially, she wants to remove him.
Okay. I think I also misunderstood it. So she could work with Tyler, for example, and figure out how to buy his interest of the property out.
Yeah, she could refinance him out and pay him up that way. It depends on how far along they are. If she was able to qualify by herself, we would basically just do another loan on that property, removing him. She would not be able to do a VA loan now or in the future unless she's married to him, and if he's on the loan. So if they split, she's definitely not going to be able to do the VA loan. She would have to most likely refinance it into her name. And if there's an agreed upon buyout, he gets half the equity, or whatever they're able to do, that's how that would play out.
Okay.
But tell your client that she shouldn't do anything unless it's in writing and an agreement between the two of them.
Okay.
Okay.
Definitely start with Colleen, the family law side, get that all squared away. RN's relatively simple. It's just do the numbers work. So
okay. Then I'll have to reach out.
And people buy each other out on properties all the time in family law, but the place you have to start is a written agreement first, so that now you've got it, it's in writing. Everybody knows what's going to happen. Everybody knows what the numbers are. And if something goes awry, you have the court to enforce it as well.
Okay.
So that would be my biggest piece of advice. Don't do anything. Don't assume anything until it's in writing by a court order, a stipulation, it's an agreement, and she's got to file first, obviously.
Okay. All right. Very helpful. Thank you.
You're welcome. Sorry, I didn't understand you the first time.
That's okay.
Anything else that you guys want to pick my brain on, or other weird situations you've seen? Otherwise, we can.
Some regarding trust, but I have a feeling that could be a whole nother presentation in itself.
I was going to say the same thing. I have a lot of clients that are interested in putting their properties in a trust, of which I know nothing about.
Okay. Well, certainly if we can meet and we can talk about it too, so you know how to talk about it with your clients. And if you're interested in being put on my my newsletter, that'll give you some information you could forward to your clients as well. And our Facebook page, we throw out some information on there. We do we're starting to do like weekly or not, monthly questions to attorneys. We call it coffee talk. I mean, people can post questions
Okay.
and we'll post that on there too. But if you want to meet up sometime and talk about trusts, I know that's a really exciting topic of conversation. But if you have a lot of clients that are interested in it or want to know more, at least it's a starting point with you, and that you understand how they work as well, so that you can have more meaningful conversations with your clients.
Perfect.
And that sounds like could be a good topic as well for another webinar too. So we could throw that one in there and get some people on and talk a little bit more about the trust planning, I guess, as well. So
I would love to do that. I would absolutely love to do that, because I think a lot of people don't understand. It's again, taking title. They don't understand. They don't have all the information, and they're like, they assume that a will and a trust are the same because they think they're interchangeable words, and they're really not. So I would love to be able to talk about that as well.
perfect. Well, then we will get that one in the works as well, and definitely let you guys know when that one's coming.
Great, wonderful, and we could do it in the morning as well if that's easier for everybody too. I get my situation here figured out with my kid, but it's all working out.
Perfect.
Babysitting. Yeah. Okay.
Awesome. Well, any other questions?
None at this moment, but I'll definitely reach out to you, Colleen.
Perfect. I look forward to it then.
Thank you.
And Connie, I'll see you tomorrow.
Bright and early.
Perfect. Well, Colleen, thank you so much for joining us. I absolutely love the presentation. Love the Outlander references as well. I had to kind of had to block some out because I'm not sure where you are, where I am in the show. So
nothing that I said today has any, no spoiler alerts at all whatsoever.
You mentioned kids, and I'm like,
yeah.
Awesome. Well, thank you again.
You're welcome.
And yeah, we'll see what we can do about getting some other ones going here. And thank you guys so much for joining us.
Thank you. I'll have a good day, everybody.
Thank you, Colleen.
Thank you.
That was great.
You're welcome. Bye.
Bye-bye.